Okuma biomesiede ebu. Okuma biomesiede o ebu ma. Uhame okusi. Ologoma okusi o abaewae. Dami ho. Where you walk by you tanta. Uri o walk by ye gele gele. Utatano eviarugiso OGIAMIEN. Good evening, ladies and gentlemen. This time around, this is the Sydney Table Talk Show, the STTS. I am going to be presenting the public press announcement by the State Attorney General, Barrister Oluwole Osamundiame Iyamu of the Edo State Government. He said, statement by the Office of the Honorable Attorney General and Commissioner for Justice, Edo State, regarding the OGIAMIEN chieftaincy and matters related thereto. It has been brought to the notice of this office that a controversy appears to have arisen or been manufactured, arising from the recent exercise of powers of my office in exercising nolle prosequi or withdrawal of a criminal charge in charge number MOR 148C 2015. In order to set the record straight and prevent people with a political agenda from misrepresenting the facts as they relate to this matter, it is necessary to recount the sequence of events that led to the current situation. 1. Sometimes in 2015, during a period of traditional transition, Benin Kingdom, a certain Rich Arisco Osemege made claims to various newspapers and other electronic media to be an alternate traditional ruler within Benin Kingdom and described himself as Emperor of Utantan Kingdom of Benin. 2. The same claimant followed up this act by instituting an action at the High Court against, amongst others, the Benin Traditional Council, the Edo State Government, and other traditional authorities in Benin Kingdom, with a view to securing a court order to restrain the coronation of His Majesty Oba Eware II as the Oba of Benin. 3. It was my duty and honor and privilege as the then Solicitor General of Edo State and a senior advocate of Nigeria to work alongside other senior counsel of Edo extraction who successfully combated and ultimately defeated this claim right up to the Supreme Court of Nigeria. The cost of this litigation was borne by the Edo State government. 4. As a corollary to the then ongoing civil claim in 2015, the Ministry of Justice, through the Office of the Director of Public Prosecutions, filed number MOR 148C 2015 against the said Rich Arisco Osemege for the misdemeanor offense as provided in the Traditional Rulers and Chiefs Law of claiming or allowing himself to be referred to as a traditional ruler not having received the sanction of the law or recognition of authorities to that effect. 5. The purpose of the said criminal charge filed in 2015 was to bring maximum pressure to bear on the said Rich Arisco Osemege regarding the escapade he had embarked upon, which we deemed at that time to be a clear and a present danger to the peace and tranquility of Benin and the entire state. 6. With the eventual dismissal of Rich Arisco Osemege's claim by the Supreme Court, there no longer existed any legitimacy whatsoever for the claim of being a traditional ruler, which had previously been pursued by the said Rich Arisco, allegedly on behalf of the OGIAMIEN chieftaincy family of Benin. 7. Furthermore, by letter dated 4th of April 2022, 7 years after the institution of the charge, the said Rich Arisco Osemege wrote to my office formally and without reservations, renounced all claims of sovereignty with His Majesty the Oba of Benin, all competition with the palace of the Oba of Benin, and vowed to maintain cordial relationship for the peaceful development of Benin Kingdom and put an end to the legal tussles in various courts. 8. In response to the said renunciation letter, I came to the considered view that the prosecution in suit number MOR 148C 2015 served no further public policy purpose, and therefore exercised my powers under the Constitution to put an end to the same. 9. It must be noted that a withdrawal of charge by the Attorney General on grounds of public policy does not amount to an acquittal in respect of the charge in question and cannot be a bar to future prosecution if the subject either fails in his undertaking or continues in the commission of the offense. For the education of those who might not be aware, the paramount traditional ruler in the 7 local government areas which make up Edo South Senatorial District is a reserved monarchy, His Majesty Omonobane Doku Akbolokbolo Oba Eware II, the Oba of Benin. It is within His Majesty's prerogative to appoint and exercise authority over any chief within His Majesty's domain, howsoever they may be called or described. It is not and has not been hitherto been the duty or the responsibility of government to appoint or recognize chiefs within Benin Kingdom outside the prescribed authority of the Royal Palace of Benin. The Edo State government, therefore, has no recognition role in appointment activities of anyone claiming to be a chief. At the risk of repetition, that is entirely traditional, a cultural matter within the domestic authority of the Royal Palace of the Benin Kingdom. This office will therefore appeal to all persons seeking to project an impression of conflict between the government and the palace on this issue and or any other issue for that matter to find other avenues to exercise their energy and imagination, as this office has absolutely no intention, desire, or even legal responsibility in that regard. On a personal note, it must be stated that the office of Attorney General as created by the Constitution has a long and a distinguished pedigree in our state, and I am proud to be a mere temporary custodian of the enormous powers granted by law to this office to protect and promote the common public good. I assure all and sundry that I do not take this responsibility lightly. Oluwole Osamundiame Iyamu San, Honorable Attorney General and Commissioner for Justice, Edo State. Mr. Oluwole, I think you are trying to play a very, very dirty game, That the state government does not have powers over how chieftaincy stools are instituted is an insult on the part of the state government. Not only that, it's an affront. Anyway, before I go further, let me read to the public the reply of the OGIAMIEN royal family to this very particular press release. All right. The great OGIAMIEN royal dynasty. Refutal. Restatement by the Office of the Attorney General and Commissioner for Justice, Edo State, regarding the OGIAMIEN chieftaincy and matters related thereto. Our attention has been drawn to the publication on page 32 of Tuesday, June 22, 2022 in the Vanguard newspaper, credited to the Office of the Honorable Attorney General and Commissioner for Justice, Edo State, regarding the OGIAMIEN chieftaincy and matters related thereto, in which to react as follows. Ordinarily, we would have ignored the publication under reference for 2 reasons. The first, since the Edo State government had already entered nolle prosequi on our behalf or withdrawal of a criminal charge in charge number MOR 148C 2015. Secondly, for the fact that you spoke not on behalf of the Edo State government, which already granted us the waiver, but seeing the many lies, falsehood, and deliberate destruction of facts as displayed in the publication under reference, while recounting the sequence of events that led to the current situation, we have decided to react to keep the record straight. Item number 1. There was never a time our king OGIAMIEN Rich Arisco Osemege JP made claims in various newspapers and other electronic medias to be an alternate traditional ruler within Benin Kingdom and described himself as Emperor of Utantan Kingdom of Benin. Rather, we installed him as the OGIAMIEN of Utantan, which is in line with the provision of the Midwestern State of Nigerian Gazette number 59, volume 5, MSLN number 37, dated 7th day of November 1968, tied to the Constitution of the Federal Republic of Nigeria, Constitution Suspensions and Modifications Decree 1966, Chief Law Cap 19, which is also protected by Part 4, Section 38 and 39 of the Bende State Traditional Rulers and Chief Edict of 1979, now applicable in Edo State, marked Appendix A. In addition to these legal instruments, the OGIAMIEN title, OGIAMIEN Royal Palace, had been gazetted as a national monument by the colonial masters in 1959 and handed over to the federal government of Nigeria during the independence of 1960. The OGIAMIEN title, therefore, is not only a statutory but a legal instrument exclusively preserved and is a prerogative of the OGIAMIEN Royal Dynasty. All the 24 OGIAMIENs we have installed from inception to date, we have never taken permission from any person, be it the state government or any traditional ruler. In January 2010, in his response to our letter dated 15 March 2010, marked Appendix B, through the Secretary, Mr. Frank Irabo, Benin Traditional Council, Oba Erediawa admitted that to the best of our knowledge, the title OGIAMIEN has not been taken from our family and that the OGIAMIEN do not live in Benin City. In this letter under reference, he addressed Pa Edwin Ogbomo Ogiame as Ezomo of Utantan, care of Ogiame Palace, Ogiame Quarters. He, Oba Erediawa, thus confirmed the existence of Utantan, Ogiame Stool, and Ogiame Quarters located inside Utantan. All this created by the provisions of the memorable Ekiopaga Treaty. This letter, which speaks volumes, expose your weakness, your poor knowledge of the true history and position of the great OGIAMIEN royal dynasty in Benin. So, we would like to counsel you to tread with caution. Thus, your allegation that our king claimed to be an alternate traditional ruler within Benin Kingdom and that he described himself as Emperor of Utantan Kingdom of Benin, therefore, is null and void. To us, this is deliberate distortion of facts to deceive the public. Items number 2. The current Oba of Benin, Oba Eware II, petitioned us to the then Commissioner of Police that we have no right anymore to install our king and that the title has been taken by them without our knowledge and that as such, we have committed a criminal offense and sent our king and his brother to prison for offense they did not commit. They made it difficult for us to bail them and we went to the High Court and got them released. In the process, the coronation of Oba Eware II was in progress, and he vowed that he will circumvent the Ekiopaga Treaty, which we objected. We secured a court order to restrain the coronation, and the appeal court granted us the relief, asking us to maintain the status quo, marked Appendix C. But your principal went ahead in defiance of the court order and installed himself as Oba Eware II. Items 3. Having disobeyed the court order to maintain the status quo and installed himself as Oba Eware II, the matter did not go beyond that state. So how you walked along the other senior councils of Edo extraction and successfully combated and ultimately defeated our claim right up to the Supreme Court of Nigeria is what we do not know. And most shocking is that the cost of litigation was borne by the Edo State government. We hope you did not cash in on this to extort some money fraudulently from Edo State government, ? Items number 4. By the 1959 Colonial Masters Edict handed over to the federal government in 1960 and the Midwestern State of Nigerian Gazette number 59, volume 5 and MSLN number 37 dated 7th day of November 1968, titled The Constitution of the Federal Republic of Nigeria, Constitution Suspensions and Modifications, Decree 1966, Chief Law Cap 19, which is also protected by Part 4, Section 38 and 39 of the Bendel State Traditional Rulers and Chief Edict of 1979. OGIAMIEN tied to the OGIAMIEN Royal Palace were already statutory and legal instruments, then, under which law, the Office of the Director of Public Prosecution filed charge number MOR 148C 2015 against the said Rich Arisco for the misdemeanor offense as provided in the Traditional Rulers and Chief Law of claiming or allowing himself to be referred to as the traditional ruler, not having received the sanction of the law or recognition of the authorities to that effect. What stops you from mentioning the particular law under which the king was charged to court, since he acted in accordance with the existing law? Question. Items number 5. We did not install him as Oba of Benin, rather as OGIAMIEN of Utantan in accordance with the memorable Ekiopaga Treaty and in line with the 1959 Federal Government Gazette and the 1968 Midwestern State Edict. And how did that present danger to the peace and tranquility of Benin in the entire state, using your own words? Item number 6. There was never a time the Supreme Court dismissed our claims. Rather, when we filed a motion for additional information, There was a typographical error of Court of Appeal instead of Supreme Court. Our attention was drawn to it. We withdrew our motion to enable us to refile the motion, and the Supreme Court struck out the application for the additional motion due to the error. We have since last year refiled the additional motion and has been given dates for the hearing before the Edo State government came into the matter. We are shocked to learn that the Supreme Court dismissed our claims when the substantive case has not even been entered into. Are you telling us that a legal luminary of your standing does not know court proceedings vis-a-vis when a case is struck out and when a case is dismissed? If you are not mischievous, if our case were already dismissed by the Supreme Court as you alleged, what case did the Edo State government ask us to withdraw from the Supreme Court? Item number 7. We were also shocked to learn that you shamelessly made reference to our letter dated 4th April 2022. In this letter under reference, which speaks volumes upon volumes, our king made himself loud and clear. Memorandum of undertaking of the office of the OGIAMIEN of Utantan Kingdom vis-a-vis the Palace of the Oba of Benin in charge number MOR 148C 2015. Commissioner of Police versus Rich Arisco Semege and Patrick Osaboye. I, Honorable Rich Arisco Semege JP, the OGIAMIEN of Utantan Kingdom, hereby state clearly that I am the OGIAMIEN of Utantan Kingdom of Edo State and not the Oba of Benin. The title of the Oba of Benin belongs to the Oba of Benin royal family, while the OGIAMIEN of Utantan Kingdom belongs to the OGIAMIEN royal family. As the OGIAMIEN of Utantan Kingdom, I am not in competition with the Oba of Benin. The Oba of Benin and the OGIAMIEN of Utantan have lived peacefully for centuries without any rancor, and I pledge to maintain that cordial relationship for the peaceful development of Benin Kingdom to put an end to all the legal tussles in various courts. I have decided to write this letter to you as the Chief Law Officer of the state so that the issues in the above-mentioned case can be resolved. Thanks, Honorable Rich Arisco Osemege JP. Now, we go to number 4, the OGIAMIEN of Utantan. There is nowhere in this undertaking our king admitted that OGIAMIEN was a chief under the Oba of Benin. Why did you accept this undertaking before publishing the nolle prosequi? In addition, in your acceptance letter dated 13th April 2020, page 2, items A, you ordered our king to revert to the official statutory position as OGIAMIEN of Benin, which was in line with the 1968 edit and the provision of his renunciation letter. Was it that you do not know the legal implication of this order to revert to our official statutory position? Item 8. According to you, in response to the said foregoing renunciation letter, you came to the considered view that the prosecution in suit number MOR 14AC 2015 served no further public policy purpose, and therefore exercise your powers under the Constitution to put an end to the same. The questioner is this: why are you crying wolf? Because in the said renunciation letter, our king made it loud and clear he is not contesting the stool of the Oba of Benin. Rather, he is the OGIAMIEN of Utantan, which is in line with the provision of the Akiopa Treaty and the 1950 Federal Government Gazette and the 1968 edit. Items 9. We thank you for the withdrawal of the charge based on the conditions of the letter of renunciation written by our king. By the contents of the letter of renunciation and the nolle prosequi, we are confident that it is now a bar to official prosecution. So as long as we continue to uphold the contents of renunciation letter, which is clearly stated, we are not a chief under the Oba of Benin. Rather, we are the OGIAMIEN of Utantan. Your claims that the Oba of Benin is the paramount ruler of the 7 local government areas which made up of Edo South was the power he is ascribed to himself in the fraudulent 1979 Bende State Traditional Rulers Edit. Even at that, the OGIAMIENs have never been under the Oba of Benin from the inception date. It is within the Oba of Benin's prerogative to appoint and exercise authority over any chief within His Majesty's domain, howsoever they may be called or described with the inception of the OGIAMIEN, which is far older than the Oba of Benin. Finally, while thanking you for efforts in entering the nolle prosequi, please endeavor to tell the whole world, the truth of what transpired between you and our king. The impression you are giving is misleading and may lead the Benin Traditional Council into grave mistake. You are giving the impression as if our king accepted to be a chief under the Oba of Benin, and that is why they are still making the same mistake again and again. We have said this repeatedly, and that we are not interested in the stool of the Oba of Benin. We install our king as the OGIAMIEN of Utantan and not as Oba of Benin. H.C. Mondewere, JP, Director of Information and External Affairs. You see, my brothers and sisters out there, you have heard both the press release of the Attorney General of the state, and you have heard the release and the reply or the refuter of the OGIAMIEN royal family. Well, the fact is, I think I can challenge the Attorney General. If there is anybody actually who has committed any criminal offense, it is the Oba of Benin, because there is nowhere in Nigeria a chief can install a chieftaincy stool. What a chieftaincy stool can do in Nigeria is to sort of give out chieftaincy titles, and these are honorary titles. Like I repeat, like the Obasogi of Benin, Obehun of Benin, Obisan of Benin, Oba Nonsense of Benin. These are the titles that the Oba of Benin can create. Chieftaincy stools are under the prerogative of the state. It is the state that is responsible for creating the chieftaincy stools. So, Barrister Osamudi Ahmed, don't deceive yourself, because we live in Nigeria, and Edo State is not the only state in Nigeria. Let me give you a typical example. If you come to River State, Obiakpo local government area used to have 3 royal stools. But today, the state government came and then created, or we can say upgraded, over more than 70 chieftaincy stools. It wasn't the original chieftaincy stools that came and then created new chieftaincy. It was the state. If you go to Lagos State, it's the same thing. In Lagos State, you have over 150 third-class chieftaincy stools. All these stools were created by the state government. They were not created by the Oba of Lagos or by the Oba of Ekpe or by the Oba of Badagry. No, they were created by the Lagos State government. And this brings me to a very, very important conclusion, Now, I think that the time has come for the Edo State government to abolish the 1979 chieftaincy laws. What the state government should do is to abolish these laws. And to be honest, the state government should pick a copy of this law, give it to what I call lawyers who are not of Benin extraction or who do not even come from Edo State. Give it to lawyers from other states, even in the Western state, the Yoruba state, I don't care. Let them study these laws. They will discover that this law is in a serious conflict with the state government. This law has placed the Benin Traditional Council at par with the state government. And this is why the Oba of Benin is often raising his head anytime, whenever talking to the state. I'll give you a typical example. What the state government should do here is put together all the gazetted chieftaincy stools in Edo State before 1979. All the gazetted chieftaincy stools in Edo State before 1979. Put them together. Then there are chieftaincy stools that were not officially upgraded or given staff of office or gazetted. These are chieftaincy stools that were already there before 1897, because those that were not, the post chieftaincy stools in the current Edo South or Edo State, they were all invented by the Oba of Benin as a way of stealing lands from people, depriving people of their resources. This is the truth. The state government should go and identify those chieftaincy stools, the pre-colonial chieftaincy stools. As I will give a typical few that I know. Odoliji of Igbanke, for example. Ugiugno, Elawura of Use, ESF Udo. I think Ogiobe himself. We have Ogiegba and we have Ogiulegun. You see the way they are called. They are not called Enogi of Ulegun. It was from 1979 that these people's titles were now turned to Enogi of Ulegun. There is no Enogi Ulegun. Ulegun, originally is known as Ogiulegun, Ogiegba, Odoliji of Igbanke. Now, from 1979, another thing I want to put clear here is that, you see, the 1979 chieftaincy law created serious problems for most of these traditional stools. For example, prior to 1979, the installation of the Odoliji of Igbanke was not the prerogative of the Oba of Benin or the BTC. The BTC does not play any role in the installation of the Odoriji of Igbanke, like it does not play any role in the installation of the OGIAMIEN, like it does not play any role in the installation of the Ogiobe, or the Ogiobe, or Ogiegba, or ESA of Udo, the Benin Traditional Council, or the Oba of Benin. They never played any role. For protocol purposes, whenever these people are installed by their families, because there are internal regulations within these families for their installations, the various families, they only communicate with the Oba of Benin because it is a normal thing. These were protocol reasons. It is not submissive. We are not talking of submission. These people were not submissive. There was protocol reasons. It's like when you make the governor of Edo State, the governor of Edo State officially has to write to the federal government, apart from the fact that the INEC had already declared them as Obaseki as the governor, but the state government must officially equally inform the federal government, this is now the new authority in the state. All right? This is exactly what happened. What was happening between these institutions at that time was protocol. The Oba of Benin had never at any time been instrumental to the installation of any of the above titles that I have named. Otherwise, one would have asked a question. By 1897, when the British invaded Benin Kingdom, why these people never came out to defend the Oba of Benin? They never. They were all autonomous. They lived on their own. Because what the Oba of Benin was doing before 1897 was go to these territories, not to the territories that were close to this family. They go to some of the hamlets. Because, you know, at that time, 1897, we're still talking about hamlets. They go to raid people for slavery. They didn't touch those royal families who were ruling those territories. They go and raid people. You cannot call this authority over the king of those territories or over the duke of those territories. So this is exactly what the Oba did. And now I think that, like I have suggested, the state government should make a review and a restructuring of the Edo State Chieftaincy Institution. The Oba of Benin is busy enriching himself and his families and his immediate clans, while majority of the families that owns the resources today are all impoverished. Take another example. How many dukedom did the Oba of Benin create? Let's put it this way. How many dukedom came from the Oba of Benin in Iyekoriomo, Ikbobaoka, Unhude, these local governments? How many dukes did the Oba of Benin actually instituted in this territory? The Oba of Benin by 1897 had no dukes in these territories. Even in Ovia, he had no dukes. Iyase was not a duke to him. Iyase was an autonomous and independent traditional ruler. Iyase comes from his family. We all know the facts and the story of the Iyase is there for us to see. But by 1979, Erediawa would introduce a clause into the chieftaincy's edict, which finally subject all these people to him as his chiefs. And again, these people earn their salaries through the Oba BTC. Therefore, they become submissive, because when they do not do that, they do not get their salaries. These are part of the monopolistic instruments that the Oba of Benin has been using on these people. It is very, very, very important that the state must come to find a solution to these problems. Edo State or Edo South does not belong to the Oba of Benin family alone. For God's sake, we should apply our senses. The Oba of Benin had his territory by 1897. He cannot now begin to send his brother anywhere. They've gone to Ologbo. They have sold all the lands in Ologbo. They are beating people in Ologbo. They incarcerate people in Ologbo. They arrest them. They send thugs. They send police. They send the army, because they have all these instruments, because they have been able to acquire a lot of money by selling people's lands. So whenever you oppose them, they use these huge financial resources against you. I am calling on the state government to take into consideration that the 1979 chieftaincy edict must be seriously reviewed You have people who are lawyers from River State. You have Obaseki, Governor Obaseki, Your Excellency, sir. You have people who are lawyers from Ondo State. Give this edit to them and let them look at this edit. They are going to tell you that this edit completely flaunts the law of the Federal Republic of Nigeria, and it completely put the state in conflict. The Oba of Benin uses this edict to sort of create a state, a kingdom within a state, a feudal system within a state. It's unacceptable. It is unacceptable. I'll give you another example. What is the problem with the Olu of Warri's royal family right now? It was in 1979, the same 1979, the Oba of Benin introduced the clause into that chief edict that whosoever that must become the Olu of Warri, the mother must be Ushekiri or Benin or Yoruba. He decided, but for God's sake, the Olu of Warri's title has been there since the 15th century. How come was it in 1979 that the Oba of Benin would now become an authority over that title, an authority to instrumental to the decision of how the Olu of Warri is installed or selected? Just the same thing. Now go to Warri. Prince Ayiri is in court with the current Olu of Warri, but I'm sure that Prince Ayiri is going to lose, because before the current Olu of Warri, before 1979, there were Olu of Warris whose mother did not come from Yoruba, Ishekiri, Benin. There were. The history is there. I am not going to be here telling you who and when, but the Ishekiris, they know this, that there was an Olu whose mother did not come from these three tribes that the Oba of Benin included in that very particular chieftaincy too. All right? The same problem happened in the same 1979. The Obi of Owalero, which is the traditional or the ancient city, the ancient town of Agbo, was placed under the Deni of Agbo, and the Deni of Agbo was now converted to become the Obi of Agbo. But today, this same law, this Bende State Chief Edict of 1979, was thrown away by the Delta State government. And the Delta State government came up with a new chieftaincy law. And a lot of traditional stools were now upgraded by the state to give what we call equilibrium. And not only that, to allow for the distribution of wealth amongst the people. We are living in a situation whereby Edo is not a democratic state. The Oba of Benin, who will be sort of wanting to oppress the Elawure of Use, was the Elawure of Use under the Oba of Benin? The Elawure was not under the Oba of Benin. Otherwise, by 1897, the Elawure, who is even a blood relative of the Oba of Benin, would have defended the Oba of Benin. If the Oba of Benin had power grip over this, if actually he was in control of these territories that he's claiming today, it would have taken the British 5-6 years to defeat the Oba of Benin. But because he was a noisemaker, he had nothing, he was just making noise over nothing. And these people, when the war came, he was even ashamed to tell them that he had problem with the British. He could not tell them because he had already lied to the British that he was in control. Because if he had told them that he had problem with the British, these people would have gone to the British and said, look, we are not with this man. So he kept mute and silent until the British came, overpowered him, and these people were all surprised when the British started taking over their territories, including the OGIAMIEN. The then OGIAMIEN Ogiawere himself was arrested. Not only that, the Obi of Owalero himself was arrested. So please, my public, we should avoid being sentimental over serious issues. This is not an issue we should be sentimental. Whatever I am saying is due for reconsideration. Good night and thank you all, and may God bless you.